lo medular dentro del testimonio de Luis Antonio Cádiz en horas de la mañana de hoy ha sido como el licenciado Edwin Prado ha sido mencionado constantemente dentro de todo este proceso. Eso es algo que obviamente salta a la vista dentro de todas las declaraciones de Luis Antonio Cádiz y sobre todo porque él, a preguntas del Ministerio Público, indica de que el señor Edwin Prado fue la persona que lo indujo a mentir en la primera reunión con el FBI y también en sus propias palabras también indicó cuando él fue al gran jurado.
Félix Verdejo Sánchez's legal team has challenged his conviction, claiming that there has been mistakes made during the trial. According to the petition, his defense is looking for possible legal errors or procedural issues, including incorrect instructions given to the jury, mishandling of evidence, or misapplication of the law. Verdejo Sánchez was sentenced in November of 2023 to a 2-life term for the kidnapping and murder of the 27-year-old Keishla Rodriguez Ortiz and her unborn baby. The tragic event happened on April 29, 2021 in San Juan, Puerto Rico. Félix Verdejo Sánchez's attorney Michael Hasse filed a motion on October 31st asking the court for access to several key documents, including transcripts from the pretrial conference and private conversations. In response, Federal Prosecutor Jonathan Gottfried filed a motion stating that he has no objections to sharing the information. However, he didn't specify whether the defense should receive the paper in copies or an additional PDF file. Later, Federal Judge Pedro Delgado actually answered and gave Félix Verdejo's defense until Friday, November 7th, to clarify whether they're asking for access to all documents in the case file or just the ones previously available to the former attorney. Judge Delgado also noted that the case file includes materials with restricted access, includes documents tied to Luis Antonio Cádiz Martínez, the co-defendant and star witness in the case. Cádiz Martínez was sentenced to 20 years in prison and 5 years to supervised release. The judge also asked Verdejo's legal team to confirm whether they have any objections to allowing the federal prosecutors to have the same level of access to those restricted documents. In response to the judge's request, Michael Hasse presented a 7-page motion on Friday in which he argued that the documents are necessary to write the appellant's letter. He added that due to the recent imposed restrictions as well as a cyber attack on the CMECF system of the filing of federal cases, their access to the district court files has been limited. So basically there has been a cyber attack right now in the system, so he cannot get any files even if they were granted. In this case, an unusual high number of restricted documents were presented due to the concern of advertising, the enormous media attention, the promotion on networks, and the court's gag order that limits the public's disclosure. He stressed that, however, all those restricted documents that were identified as essential for examination and analysis of this appeal case, which requires a complete review of the trial file. The lawyer maintained that all the documents revealed must be equally available to both parties. It also considers that the sealed appendix of this case should, as far as possible, be presented as a sealed joint appendix in order to avoid the duplication of restricted documents and facilitate the reading and understanding of the writing of both parties, said Hasse. He explained that since he did not represent Félix Verdejo in the case before the federal court in Alto Rey, he understands that it is crucial to obtain and examine this material, whose access has been limited, to determine if additional transcripts or documents are needed. This access is also necessary to properly present the appellant's argument on appeal and to compile a comprehensive sealed appendix before the First Circuit. He indicates that his main responsibility regarding the file of the court of the first instance is to thoroughly review them in its entirety and to identify possible legal or procedural errors that have affected the outcome of the case. This appeal is based exclusively on that file. No evidence or new testimony can be introduced. The center of an appeal is to identify specific legal or procedure errors committed by the court. For example, erroneous instructions to the jury, undue admission or exclusion of evidence, or incorrect application of the law, that have been timely raised and preserved during the trial. Cases not raised in the court or First Circuit are generally considered waived on appeal, except in exceptional cases of manifest error. So now let's break this down in black and white so everybody understands what an appeal is and how to get an appeal. See, an appeal isn't about re-arguing the facts of the case or presenting new evidence. Instead, it focuses strictly on legal or procedural mistakes the court may have made. Examples include: the judge gave the jury the wrong instructions about the law. The judge allowed or rejected evidence that should have been made. The judge misapplied the law to the facts. When these issues must be raised, these legal errors must have been brought up and recorded during the original trial. If a lawyer does not object or raise the issue at that time, it's usually too late to complain about it on appeal. Now, what happens if the issue wasn't raised? If the issue wasn't raised in the lower court, the court of first instance, the appealing court will normally refuse to consider it. However, there's an exception. If the error is so serious and obvious that it's called a manifest error, meaning it's plain, fundamental, and affects justice, then the appealing court may still review it. You can't use an appeal to start over or try a new argument. You can only argue that the original judge made a clear legal mistake, and only if that mistake was properly objected during the trial, unless it's a rare, undeniable major error. For this reason, he insisted that he requests that both he and the federal prosecutor's office receive copies in paper and PDF format of the restricted documents and duplicates, since this will facilitate the creation of a joint stamp appendix for the First Circuit.